Yes, call. Please don't mention.
I'm not mentioning.
My lord.
Yes, yes.
Mr. Bandopadhyay will like to make some submissions today.
Pardon?
After me, sir.
We are closing the hearing today.
Today only. Today only. he'll-
Yes, then don't mention. Okay, take your seat. When he comes, he will make his
My
argument.
lord, with leave of your lordship's court, my lord, I am not mentioning, but I am just ventilating my grievance, my lord. We 27 of the petitioners had taken out an application for inventory. My lord, the petitioners are, my lord, my lord, candidates who have been given appointments after expiry of panel.
Sorry. This
But my lord, kindly sees, my lord, but
sorry, sir. We have
one line, my lord, kindly sees, my lord, we have been appointed by order of court, my lord.
sorry, Mr. Mojumdar. Where is Mr. Mojumdar?
Only one point.
Yes. Come. Mr. Sharnal, you have finished. Yes.
No, my lord, the last point, your lordship, Mr.
You have told us yesterday. Yes, Mr. Mojumdar.
That, my lord, something's to be.
No further argument on your part. Mr. Dotto, we have allowed him sufficient opportunity. Yes, Mr. Mojumdar.
My lord, only one thing, this the clause in the advertisement that he can opt for other councils.
Who does that?
Losses because the legible copy was probably not there to your study.
For exercising of option, you showed us that.
Pointer দেখাতে পারতো আরেকটা কপি আছে তো
আচ্ছা
Now, you losses kindly see these are the advertisement notification first clause. I put a tick mark for this.
Yes.
My lords, may I have my lord's permission to address?
First point number 1. Any candidate shall be allowed to apply for the post of a primary school teacher of a particular council only against the post advertised. Particular council he can choose. And then you'll also see the next form fill up. Now you'll also
No. What is your interpretation? Any candidate shall be allowed to apply.
any candidate shall be allowed to apply for the post of a primary school teacher of a particular council. So council was not fixed. He can choose any particular council. A candidate of Kolkata council can choose for Darjeeling council. For example, I'm saying for a particular council for the post advertised. Now you'll also kindly see the application in the next.
Where?
Losses will find after email ID. Your losses will find this roll number 19. 19 stands for District Birbhum code. Roll number. Second column, your loss. Second column. This is state roll number, my lord. 19 stands for Birbhum.
Date you said that there was a unique number.
This roll number was treated all along by the board as unique identification number.
And the number added with this district code.
District code.
Then what is your argument?
Argument is that, my lord, a particular candidate, this number 19 or 18 denotes the particular district he applied for TET. Now he has been given option, he can choose another district with this roll number. That's your lordships in this application form. Kindly, my lord, go little down. Email ID.
Yes.
Just thereafter. Preferred district for counseling, recommendation and appointment. If empaneled, he has chosen Kolkata. This particular candidate, I'm giving an example, chosen Kolkata.
All right. Yes.
The next one also. But all in this chart, your lordship, most of them belongs to the other medium, or most of them chosen different districts. So number cannot be equal. Cut-off marks, no, last empanel candidate numbers. There is no cut-off number. Cannot be equal. That's our submission. And Mr. Ahmed says all are Bengali media. That's absolutely not correct. Because showing that Most of the, I can give example right now to your lordships. Some of them from Bengali, Hindi medium, some of them Urdu medium, some of them Telugu medium, Santhali medium.
All right. Yes, Mr.
Lordship, with your kind permission, Mrs. Arora is online. Your Lordship had said should start.
Yes, yes.
My lords, I'm so grateful. I will be very brief and just to the point because a lot has already been addressed before my lords.
Item number, mat number 1616. Mat number 1616 of 2023.
MAT 1616.
Of 2023.
Item number 28.
Item number 28, Lordship.
20. Yes, madam.
Please, my lords. My lords, I'll be very, very brief and only to the point because there's a lot that has already been addressed and it's no point in repeating the same thing all over again. My lords, the very first point that I wish to address, my lords, is that right from 1951, the Supreme Court settled a principle that if there is any allegation of fraud, coercion, duress, etc., is to be made in any pleadings, this thing, it has to be supported in material particulars. And
Yes.
there, my lords, there are two judgments of the Supreme Court. My learned colleague will pass them on. I will,
Madam, you reply, we will take note of. Further
please.
judgment cannot.
Yes, my lords, I will just give the citations and I leave it with the paragraphs. My learned friend will just mark the paragraphs and give it to my lords. I do not wish to this thing. Now,
Yes,
my
you-
lord,
please.
right in 1951, the Supreme Court said that if there is an allegation that is made in respect of fraud, coercion, duress, there has to be proper case. It has to be supported in material particulars. I will just read 3 lines of that judgment of 1951.
Madam, we accept your argument. It has to be.
I am grateful. I am grateful. My lords, I need not go further. Now, my lords, I respectfully submit that the writ petition, as was filed before this honorable court, of which the impugned judgment is the one which is under challenge before my lords, is bereft of any material particulars of so-called corruption or any kind of particulars to show that there was some case that was made out which would clearly establish that there was a corruption or there was a fraudulent action on any of the candidates. This I go back to the learned single judge. My lords, my next submission taking up on this is, and I say this with all humility at my command, and I don't intend to be rude, but if we look at the judgment of the learned single judge, my lords, it appears, and I say this with humility, and I repeat that, it is like prosecutor and judge in one. And that, my lords, is definitely not permissible in a rule of law. First of all, there was no material. The learned judge relies upon some sampler material, which the learned judge finds. So he takes on some kind of an investigation, and then he carries on the cross-examination of certain interviewers by himself, to which none of us who are the affected parties were a party or could have even asked any question. And on that sample material of about 30 odd investigators, and something like, I did a calculation of the numbers of the candidates in respect of which the learned judge has observed, is 0.03% of the total candidates who had taken the exam. And on that basis, the learned judge arrives at a conclusion that there is far-reaching corruption and the entire exam of 32,000 who had been appointed should be set aside. My lords, today, when we are before my lords, the assumptions and the presumptions that the learned judge proceeded with have now been found to be incorrect in view of that charge sheet that has now been filed, where none of these allegations of corruption against any one of these 32,000 candidates has been made out. So, my lords, at the first instance, entertaining the petition was completely wrong, contrary to the principles that the courts have held in the cases of fraud, duress, coercion, etc., no material particulars. In a writ jurisdiction, the honorable judge could not have become an investigator, prosecutor, and a judge by himself. And in any case, the observations and findings of the learned judge have today been disproved by investigation, by an agency which has today investigated and found no allegation against us 32,000 odd candidates, my lords, and there is nothing which is against them. Now, my lords, I submit that's my very first point on the background that I wish to place before my lords, that in view of this fact today, after having put in more than 8 years of service, to say that today all of them should be, my lords, asked to go would be extremely harsh and punitive without there being an iota of material or evidence on record. On the contrary, the contra evidence is there on record. Secondly, my lords, I believe, and that is what I have been instructed, that there has been much emphasis to connect this matter with the 269 TET candidates who were given one grace mark and the 94 other participants who were not qualified. My lords, I would most respectfully submit that both those matters are today's subject matter before the Supreme Court, number one. And hence, this court, with due respect, may not want to go into that particular issue once that is seized off by the Honorable Supreme Court. My lords, number two, neither the 269 nor the 94 form part of us 32,000 selected candidates in this process. Now, clearly, if they are not a part of this, I fail to understand in what context is the reliance being placed on those particular candidates who are not part, who do not form part of the 32,000.
No, why do you say they are not a part of that? Because
My lords, the 32,000 who have been selected here, these are the ones who have been through the process of having the qualification of TET exam. So the 94 clearly do not have the TET qualification. They are the ones who are not qualified.
no, you have given candidates appointment by giving a grace mark.
I agree. But my lords, these 32,000,
Applied in respect of all the persons.
my lords, no. So far as we are concerned, there those people had not qualified the TET. They were given one grace mark and made to qualify. But here in our case, all of us are TET qualified. We didn't need any grace marks to be here. We didn't need any grace marks to have qualified this particular exam. We came on our own merit. We had the necessary eligibility and the qualification. Our documents and our papers were verified, and thereafter we were subjected to the interview as well as, my lords, the subject matter of our ability to impart education, the two tests of 10 marks each, 5 marks each, we were subjected to that. So, my lords, we are not in those category at all.
What about the 94 you were saying?
My lords, 94 are the ones who do not have TET qualification at all. They are not qualified. Their case was they were unqualified candidates. They were not TET qualified. They were only trained but not TET qualified. And by which time the NCTE had clearly made that TET was an essential qualification for purpose of appointment of teachers.
All right, madam. Anything else?
So, my lords, just two more very small points, and I will not dilate too long on that. My lords, issue were raised to say that the Tripura judgment, and there is similarity between the Tripura and the present matter, and in the Tripura case, the High Court had actually quashed all those appointments. My lords, I want to say there are major distinctions between the Tripura case and this case. First of all, in the Tripura case, there was a challenge to the constitutional validity of employment policy of that state itself. And my lords, that policy was contrary to the NCTE. Now, that is not the case before my lords at all. There is no constitutional validity challenge to any provisions or any rules. Number two, in the case at hand before my lords, the appointments are strictly as per NCTE guidelines so far as qualifications of the candidate, etc. are concerned. In Tripura case, in facts, the procedure was contrary to the provisions of National Council for Teachers of Education Act, which is a very important factor. Now, my lords, in our case, all the candidates have qualified, who are appearing before my lords, have passed the eligibility TET 2014. So, and after that, our academic marks were computed on a proportionate basis. We underwent the verification of all our documents, scrutiny, etc. And then, my lords, we participated in the interview and the aptitude.
Yes.
But in the Tripura case, my lords, there was only one interview that was conducted and nothing more was done. And it was a highly discretionary thing, which there was the finding of the court, but more particularly, it violated the NCTE guidelines, which are the central government guidelines for appointment of teachers. So one could not have gone contrary to that. One could not have gone contrary to the qualifications prescribed in the NCTE guideline. My lords, so far as the appointments are concerned, as my lords have now seen, and that chart sheet has been shown very extensively to my lords, there is no illegal appointments that have been found. Whereas in the Tripura matter, the selection and the appointments were found to be illegal. On the contrary, the learned single judge, based on a small data, a very, very small data, which was in a very summary inquiry, if I may say that, in a very summary nature. My lords, in a 226, one can't have an inquiry. 226 does not envisage that kind of an inquiry. Today, there is an investigation and a detailed inquiry, and which has categorically found that, my lords, there is no element of corruption, there is no element of complicity or to corruption here at all. My lords, the third point that I'll be very, very quick with is that a lot of parity was sought to be drawn with the SSC case. Because in the SSC case, the Supreme Court had set aside all the appointments. Now, there's a huge distinction and they're completely different and distinct. My lords, we must remember that in the SSC case, there was a written exam. Here, we have an interview and an aptitude test, and then we have a prior TET qualification, verification of our credentials, our documents, and thereafter we go for interview and our aptitude. In SSC case, I beg your pardon. My lords, that's my Delhi pollution showing up. So, my lords, in the SSC case, there were OMR sheets. In the OMR sheets, it was found on a fairly large number that there was actual manipulation. There was a CBI inquiry. The CBI inquiry actually reported manipulation of the OMR sheets. Now, my lords, please contradistinct that with the present case. In the present case, there is no written exam. There is no such manipulation of any answer sheets. And the investigation today has submitted a report which does not show any complicity on part of the candidates. So, my lords, to draw a parity or to draw anything from SSC exam, my lords, would be, SSC candidates would be completely, my lords, misplaced, number one, and will not fit into the present case at all. That's another fact situation altogether. My lords, lastly, I would want to make a submission. My lords, there has been that can number 2 and 3, where certain
Yes.
documents are sought to be placed before my lords for the first time. My lords, apart from the fact that it has been said on this side that those documents are forged or they are not documents which are correct in nature, but I would, my lords, ask myself a question. At this stage, in an appeal, would my lords, without having any verification of those documents, allow such documents to be placed before my lords and to be considered? Then, my lords, I would most humbly submit to you that we fall into the same trap as the learned single judge did, because he went on the basis, and I would say that with all humility, he went on the basis of what was produced before him. And that has today been disproved by a detailed investigation. Similarly, these documents, which are sought to be placed for the first time before yourself, having not been verified, not been authenticated, and specifically being alleged by the present petitioners before my lords as being forged and fabricated documents, I would request, my lords, that the court may proceed on the basis of the record that has come from the learned single judge, and please do not allow any fresh document or material to be taken on record at the stage of the appeal, my lords. My lords, I will lastly, I would, my lords, there was one other judgment, but I don't think that is necessary, that the honorable single judge could not have gone on the basis of any newspaper reports, because my lords have said it time and again that the courts will not take cognizance of an issues merely because they have been published, and that's not an evidence. That's really not an evidence.
Why you are saying newspaper report? It was not there before the single judge.
My lords, the learned single judge in his judgment and in those proceedings made observations that there's a lot of newspaper publications about alleged corruption and everything else. Now, my lords have held categorically, the Supreme Court held in large number of judgments, that mere newspaper publications are not enough evidence to arrive at a conclusion or arrive at a determination that there is an evidence of, let me say, corruption or something. I'll just give my lords a citation. It's a 2020 volume 16 SCC 811. That's a more recent one. And the relevant paragraph will be 6 in that. My learned colleague will hand over that. So my lords, but that's on the side wing today. It's an outlier, if I may say at best. The core of the matter would be that there is today no material whatsoever to show that there was any kind of a corruption in this particular examination process, my lords. My lords, I'm extremely grateful for your time. I'm very much obliged, my lords.
15 to 20 minutes, not more than that.
Mr. Bandyopadhyay, then you address what Mr. Mojumdar we
My
told.
lord, I've addressed first. Your lordship said to me, "Man, I cannot sit here every day."
All right.